Now back to the show. This is AM 650's The Law Show.
David Hobbs and Ian Giroday with us on this episode of The Law Show here on AM 650. They are, of course, Hobbs Giroday, Vancouver estate litigation lawyers downtown. Where's the office, David?
938 House Street.
And online, Ian, at hobbsgiroday.com or .ca?
.com.
All right, and you can find out a lot more about our guests and, of course, how to contact them. It's all right there on the website. Wanted to talk a little bit about executors. These are civilians. These are people with, generally speaking, no legal training whatsoever, who in many cases, out of kindness or courtesy or familial obligation, have agreed to act as executors to help resolve the estate of a friend or family member. You at Hobbs Giroday do kind of a split on this. You help and advise executors who come to you going, I'm a civilian. What am I supposed to do here? And you help them out. On the other hand, you also deal with clients who aren't in the least bit impressed, for whatever reason, with the appointment of said executor. When those clients come to you, Ian, what are their issues? Why do people get upset, and what do they want to challenge about executor selection?
Could be a host of different reasons, Sterling. One might be they're concerned about the competency of the executor to do the job.
Right.
Another might be a sense that the executor is somehow self-dealing with the estate assets. Another might be that they think that the executor is in a conflict of interest situation because there's going to be a fight as to whether property that was held in the name of the will maker and the executor was done for purposes like avoiding probate fees as opposed to being a gift to the executor. Mm-hmm. So there might be resulting trust gift issues. Might be a complaint that the executor is not getting on with the job.
As you mentioned earlier.
Right.
Yeah, okay. So, David, what about executors who come to you, and I'm sure this has happened, who come to you and say, look, 10, 15 years ago, I agreed to be the executor of my brother's estate. Well, the poor fellow died, and I'm not up to it. I can't. I'm emotionally drained. I know he was my brother, and I know I swore I'd look after his affairs, but I can't. I just can't. What happens then?
Well, I'll mention two ideas. One is we use the term intermeddling. So what might happen is the person dies. I arrange for their funeral arrangements. I start talking to their banks. And I discovered that this is not fun, and it's looking like a hornet's nest, and I didn't realize how much work it was going to be, and so on.
So now they're saying I can't, and they've done some homework.
Yeah, and we use the term, and the law uses the term intermeddle.
Gotcha.
And once you intermeddle, it's hard or harder to get out of the job. You're now in for a penny, in for a pound.
Right.
So you should make your choice about what you wish to do before you start doing anything, so that you're not caught intermeddling, and therefore the law requires you to stay and remain in charge of that administration.
Right.
Now, if you don't want to be the executor and you're named in the will, you don't have to, and you just renounce, and you file a document with the court saying, I hereby renounce my appointment as the executor of such and such a will. And now the probate registry and the world in general know that you're not going to assume that.
Right.
And normally you would contact the beneficiaries of that will and let people know, I'm not going to be your person to do this, and you'll have to get somebody else. And then an administrator would have to be appointed, or if many wills contemplate that the first executor won't act, and the will speak to
they have a backup?
Alternate.
Sure. Oh, okay.
Yeah, so there'll be an alternate. And and another topic is some people draft wills or make wills which appoint more than one executor.
Yes.
And they call them co-executors, and they have to act jointly, and that presupposes that after the willmaker dies, these people can get along and jointly make decisions. And if they can't, then those administrations are always difficult and can lead to fights between the co-executors because they can't make decisions or agree.
So what happens in that case, Ian? Suppose you have a situation where two or more individuals have been appointed to be executors for an estate, and they simply cannot coexist, let alone be a co-executor of anything. So then how does that get resolved? There's an estate here. There are beneficiaries waiting for their turn, and so on. And the executors who are responsible for making the wheels go round can't even say hello to each other civilly.
Right. So a typical situation there, Sterling, would be one of the co-executors might come and see us and say, I have this job to do with my sibling or my mom,
Yes.
but we just can't see eye to eye. We can't seem to make decisions unanimously. Well, the first thing we'll try and do is bring a little persuasion to the other side, and of course to our own client, to get along and get the job done, because that's the court's not going to lightly interfere with the will maker's choice of executors.
Right.
So the court's going to, if it comes to having to go to court and say, we would like to have this co-executor removed or replaced by someone else because we're just at, the administration of this estate is paralyzed.
Right.
You better build a track record for it.
Okay.
And you better do so not just through the evidence of what you've been told, because undoubtedly there'll be a different side of the coin, different version of what's gone on. You really should try and, in the first instance, try and get them to get along and do their job.
Right. Now, David, you talked earlier about a person who just wasn't up to the task having the legal out to be able to just renounce the assignment. In the case of co-executors, is it possible that one of them just goes, all right, I'm out of here. You do it. Can I just renounce and back out and leave the estate executor's job to the other co-appointed person? Is that doable legally?
It is doable, and a well-drafted will contemplate that so that it makes it very clear that the will maker is satisfied that if he appoints two and one renounces, he's satisfied that the one carry on alone. And sometimes wills are not drafted so well and they don't speak to the possibility, but generally if there's, say, two co-executors, one renounces, the other would perform the administration.
Right.
I think one message is, Sterling, that the will always governs. So if the will says if one of them dies before me or is unable or unwilling to act, then I appoint so-and-so to stand in that person's place. So the will itself is saying, I still want co-executors. So, if one can't act or renounces,
right,
but the will says there has to be another appointed person, that will be the first preference that the court will want to see recognized.
My thanks to David Hobbs and Ian Giroday for spending some valuable time this morning reminding us of what that article I read a few weeks ago is. My gosh, get your affairs in order in 2014. And item number 1 is a will. Hobbs, Giroday don't do wills, but you will see them if you didn't do yours well. David and Ian, thanks so much. We'll see you again soon.
Thanks, Sterling.
Our pleasure, Sterling.